closing argument. The closing argument is your opportunity to argue, your opportunity to tell the jury exactly what your evidence has shown. It's your chance, for example, in a civil case, to show that all the elements of that tort or of that count have been met. It is a chance in a criminal case to show that the defendant is guilty beyond any reasonable doubt. In order to conduct an excellent closing argument, you need to make sure that you're prepared. How do you get prepared? Well, the trial is your preparation. You have to have a point when you come into the courtroom of what you're trying to accomplish. You need to make sure that you understand that I have to prove either one, that the person is guilty of the crime, or two, that they're liable under the cause of action if it's a civil case. So I want to make sure that I know that thematically, that factually, I'm going to be able to demonstrate that. The closing argument is your chance to tell them, hey, I told you I would prove that. I then went through the trial and I proved that. And here's all the things I did to prove that. And they were unable to rebut what I say. And you should rule in my favor. You should find them guilty. You should find them liable. You should award damages. You should imprison them. Whatever that request is, depending on your type of case. So the closing argument gives you a chance, as I've said earlier, to sum up what has happened. So in other words, in a trial, you basically tell them where you're going to go. You then go there, and then in the closing, you tell them where you've been. Hey, listen, in opening statement, I told you I was going to show you this, and I showed you. So how do you perform the closing argument? Let's assume that you've done the preparation, that you understand that what you're trying to do is sum up the story that's been told, to build on the thematic approach that you had when you started that case, to help the jury to buy in, to understand factually and emotionally what you were trying to accomplish. Well, the first thing I do is I recognize that I own that courtroom, that when I do my closing argument, I'm on stage. Everybody's looking at me. The jury's looking at, what is it that you're going to tell me? How are you going to help me before I walk in the jury room in a way that I can't figure out myself? So when you're doing the closing argument, when you think about, what do I want to get that jury to do? I want to make sure that they understand that I proved my case. I want to make sure I show them in a way that when they walk into the room to deliberate, they say, there's just no question in my mind. The evidence is quite clear. Mr. Major did an excellent job when he did this, this, and this. It's hard for me to look the other way in light of what he said, what he's shown, what he did. Procedurally, when I get up, it's important to understand that that jury's been sitting there a while. Might have been a day, might have been a week, might have been a month, might be months. So it's often a good opportunity for you to show your gratitude. Ladies and gentlemen of the jury, as you know, I represent the United States of America. I've had that privilege throughout this entire trial to do so. And I want to thank you for your time. I understand that jury service can be difficult. You took time out of your busy day. You gave up work. You stay here day and night. You listen to all of our testimony, all the videos, all the exhibits, all the witnesses, all the evidence. And on behalf of myself, and I'm sure defense counsel will tell you, and the court, we want to thank you for spending the time that you did. Now, you took an oath, and that oath required you to follow the law. And let me show you how we've demonstrated the elements of murder, the elements of manslaughter, the elements to support our $1 million claim for breach of contract. Let me take you through what I told you I would do when I spoke with you first on opening statement. Let me tell you what actually happened that you saw that's going to be able to support what I promised you when we started. Now, you see what I've done? I thanked them and I moved into, I am going to sort of summarize what happened. I am going to tell you that I was an honorable person and I'm showing you what I proved. Then I want to go into a summary of what I showed. If it's a breach of contract action, I might say, as you know, and as the judge will tell you, and as I spoke to you earlier about, in order to have a breach of contract, in order for my client to recover money, he has to prove that there was a contract. that the parties agreed to a contract. He has to prove that something went wrong. There was a breach. In this case, they didn't pay for the footballs. He has to prove that there's no justifiable reason for that person to not pay. And he has to show what his damages were. In this case, $1 million. They didn't pay for the 4,000 footballs that were delivered, customized for them. Now, did we show that? Yes. You saw the witness get on the stand. You saw the defendant. You saw the defendant. He admitted there was a contract. He admitted he signed it. He admitted he received the footballs. He admitted that he didn't pay for the footballs. And what did he offer? He offered an excuse that it was a day late. He didn't show you how getting it a day late harmed him. He didn't show you that now he couldn't make the sale. He just tried to use this technical day late argument to get away with this. And you know, as intelligent people, that this is not the way to defend a breach of contract action. And this is not the right thing to do. Not only did he breach a contract, he did something wrong. And under the contract, as I showed you, that contract said we're entitled to $1 million. So this is a relatively easy case. I told you that at the beginning. I took you through the evidence, and you did not hear one witness come in here and tell you why there was a justifiable reason for him not paying. Over and over, witness after witness said, yes, I saw the footballs there. Yes, we used the footballs. Yes, we resold the footballs. You didn't hear anybody explain the justification for not paying my client for that. Do you see what I've done? What I've done is I've summarized essentially what's happened. I've summarized the evidence and framed it for the jury in that you were with me. We were standing there. We were viewers too, and we saw that evidence come in. I then want to launch into what specifically was done. Like, I want to show them the picture of the contract, or I want to show them what my damages were, or I want to replay the testimony. I want to actually say, don't believe me. Let's remember what the evidence said. Now, you'll recall when I had the defendant on the stand, you'll recall, he had that hat on and he turned his hat to the side. I might even have the hat. I might even put the hat on, put it on the side. So now they get this word picture, this visual. You remember when he turned the hat to the side and he said, if I don't want to pay, I don't have to pay. A day late, it doesn't matter if I resold them. Remember that? Remember that kind of like he leaned back and he had that kind of careless, arrogant, super silly, condescending kind of mentality? See, what I've done is I've taken the jury back in time to a specific event where something happened where now they can relate, and they're tying in to that credibility of, I told you I'd prove that, and I did. I'm also talking to them in a way that's gathering not only the objective, but the way I want them to feel. I want them to be angry. I want them to say, you remember how arrogant he was. Don't tolerate that. I'm creating an emotion. I can say, if I want, hey, did you see him when he turned his hat around? I mean, we were all there. And that sort of arrogant, head flapping back, I don't have to do anything. So what if he delivered the footballs? You see the emotion? What does that convey? What you're trying to do is you're showing them that your evidence proved your case, but you're also adding that emotional, that behavioral component of that was either a bad guy, or you shouldn't believe him, or he's not a credible person anyway. So when the other guy gets up, you're still not going to like the guy. I want to make sure in closing argument that I've gone through and shown them how I've proven my case. I've shown them critical documents that I used during the trial. If there was an admission, say in the example of where that witness said the light was green but now admitted it was red in the cross-examination. You say, you remember, the guy said it was green. Remember, the only witness in this case said the light was green and then had to concede when I showed him his sworn testimony. Took an oath under God to swear to tell the truth. He admitted, yeah, that's really what I said. What have I done? I brought the jury back to a point in time. I've used actual evidence. I've also made the call into question their only witness, their best witness, their sole witness. So closing argument is a chance for me to not only sum up and argue, but to also convey the emotion I'm trying to convey. Am I trying to convey passion? Am I trying to convey conviction? Am I trying to convey anger? Am I trying to convey frustration? Am I trying to convey empathy, sympathy? Whatever your emotion is, the most important thing to understand is that I must remember that they are there to rule on the evidence that's presented. And they are governed by a law and must rule that way. I also want to ask them things like, you have common sense. You need to bring that common sense in. You need to understand that you are going to look at these facts, and after all the lawyers have spoken and jumped up and down and yelled and screamed, it really comes down to, did we deliver the footballs or not? Did the guy pay or not? And if he didn't pay and we delivered the footballs, you're going to be commanded by the judge to rule for us. Let me show you the picture of the damages. And I bring out a picture and show the exact damages. I want to go over the jury verdict. A lot of times, jurors don't understand what that verdict form looks like. It's a piece of paper, that verdict form that says, do you find that Casey Anthony specifically and intentionally killed Kaylee Anthony? Do you believe that that intentional crime was killed with premeditation? Do you believe that it was unjustified? Whatever those sentences will say. If you don't believe that, then go to question number 4. If you do believe that, check the box here which says first-degree murder. Whatever the person is doing, whatever the act that's listed on that verdict form, I want to make sure that I show that jury that. Let me go through that again. I take out the verdict form. Let's take the Casey Anthony case. She has been accused of killing her daughter, Kaylee Anthony. Okay? The verdict form might be broken into 3 parts. It might say, was there first-degree murder? That is an intentional killing with premeditation that was not justified. Is it second-degree murder? An intentional killing that there was no planning for, that was unjustified. Or manslaughter, or negligent homicide, or whatever the third count is, where there was a killing. It may have been done in a reckless manner, it may or may not have been intentional, but there was no premeditation. So I want to take that verdict form out. I'll blow it up. It may be just one piece of paper, but I'll blow it up to 6 feet tall. And I will say, this is what I want you to do on the verdict form. And I will take them down and have them check off. Was it premeditated? Well, you heard all the evidence of how she told 16 people she didn't want her daughter anymore, and that if she had any chance to get rid of that daughter, she would. And you heard from Bob Smith, who told you this, and Tom Jones, who said that. And each one of them, one after the other, said, yeah, she was constantly bitching and moaning that her daughter was a pain in the butt and like extra baggage. Okay? Premeditation. Did she plan? You heard the evidence that she went on the websites and found chloroform and to use that as a device. You heard. Okay? That is premeditation, the planning stage. You heard that she didn't report the child. You heard that she tried to hide the fact that she killed the child. On and on. You see what I'm doing? What I'm doing is I'm taking that jury through that fact pattern. I am showing them that verdict form. I'm enabling them to understand when they go in the back, they don't have to guess. They're going to go back and say, Mr. Major told us to check these boxes, and we're checking them. So don't ever assume that the jury understands the way that verdict form is. In fact, they would have never seen it until they're handed it. And it's written always in a lawyerly way. So you must diffuse that. You must explain that. It's part of your closing argument. You want to show them that you have proven the elements and that those elements result in a verdict that should be granted in your favor. That's an important part of that closing argument to make sure that you're successful. As I mentioned, if you have documentary evidence, if you have the glove or the gun or the gory pictures or the things which you think will convey the emotion which you're trying to prove, then you also want to bring them out and use them during that closing argument so you're turning the jury on the facts and the emotion. It's very important in doing closing argument because you have to understand that they're human beings too. They're like you. They want to do the right thing. They want to follow the evidence. If you have weaknesses in your case, I recommend you talk about them. Let's say you're the state and you're going first. In many cases, a judge will already have allotted time for you to do a rebuttal. In the jurisdictions that don't allow you to do a rebuttal, you're getting one shot and the defendant's getting one shot. But let's assume for the moment you don't have rebuttal. You want to point out your weaknesses and say, listen, can we show that we actually saw Casey Anthony drive the knife in or suffocate her? Of course not. Didn't I tell you on opening statement? Didn't I tell you earlier that we weren't going to be able to show you that? That's not the case. If you don't see somebody doing it, you all have seen the television shows, you've read the reports, you know that you don't have to physically see the person do it in order for it to be murder. So what I've done is I can diffuse things. I can say, I agree, I concede, and still win. In fact, I make a joke. I say, concede everything except your case. We can't prove this, we can't prove that. You're going to, listen, they're going to get up in closing and they're going to say, we didn't do this, this, and this. It doesn't matter. Look at the elements. We showed these things. Look at here's the glove, here's the gun, here's the contract, here's the. So it doesn't matter that I have to concede some things. I actually like concession. I think concession is a great weapon. You admit, hey, I agree with you. Or I'm not trying to show you perfection, I'm trying to show you the evidence. So it's very important as part of this process to have a statement, an area of time where you're admitting that you don't have a perfect case. If you think that the defendant is going to bring something up, or if you're the defendant, you think the prosecution is going to bring something up, you want to anticipate that. Now, you're probably going to hear from the defense, like you heard in opening statement, blah, 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 blah. Let me tell you that when I sit down, I don't get a chance to get back up. So I want you to keep in mind, I want you to write down the following things, so that when the defense gets up, you're going to ask yourself, did he answer those questions? Did he overcome those things? So I want to anticipate what might happen, give them some weapons, so that when they go through that process, they will understand that, hey, he's not standing up, but it doesn't matter because his argument was on my piece of paper. You want to tell them what you want. What do you want them to do? I'm asking you to find the defendant guilty. I'm asking you to find the defendant guilty of 1, 2, and 3. I'm asking you to find the defendant guilty of all of the charges. I'm asking you to find the defendant guilty only of this charge. I'm asking you to award us money. I'm asking you to give us $1 million. Whatever you're asking for, you need to make it clear to the jury what it is you want. So, in closing, about closing, the reality is that what you've done is you're summing up the evidence, you're showing the jury how that evidence proved your case, and you're showing the jury that what that results in is a verdict in your favor. And you're showing them how to fill that verdict out so that they will succeed. This is the quintessential way to succeed in closing argument.